Thank you, Madam Chairman. Good afternoon, Justice TIjam.
Good afternoon, Your Honor.
We last interviewed you on May 12, 2014. Have there been anything significant in your career as a justice that you feel we should know about?
Well, I'm now the chairman of the 4th Division in the Court of Appeals. I think I have decided more cases. And then since 2014, I was also sent by the Supreme Court to attend a seminar in Thailand on cybercrime. And personally, over the years, I have a profound understanding of the judicial system and of what I felt are the pressing reforms that should be instituted based on my experience as a trial court judge and also based on my lectures, MCLE lectures to lawyers, and also my lectures to judges as well, and personal interviews I conduct with litigants and their seeming frustration about delays in the judicial system.
Briefly, could you tell us what would you propose should you become a member of the High Court as a way to improve the administration of justice that would greatly impact how trial court judges would, be able to dispose of their caseload? So something novel, not yet experienced by the court.
Well, the innovations made by the Supreme Court are are outstanding and good. The judicial affidavit rule, efficient use of paper, and other things. But in my lectures, my interaction with lawyers, my interaction with judges, there seems to be really a delay which is not attributable to the fault solely of lawyers or to the fault solely of judges, but I think it is what I perceive to be the infrastructure of delay. I'm talking of the organization as it is. You have the first level court, you have the second level court, you have the appellate court, then you have the Supreme Court. In my lecture on pre-trial, the circular issued by the Supreme Court is outstanding because it mandates lawyers and judges to lay their cards on the table during the pre-trial conference. So I realized that a case, when filed in court, is either meritorious or not meritorious. So therefore, if it is not meritorious, then the judge should himself automatically dismiss the case. And so with lawyers, in my lecture, MCLE lecture on legal ethics, I always propound the question, what happens if a client consults you about the case and it is not meritorious at all based on the documents shown to you, the evidence shown to you? What should you do? And I tell lawyers that if you are ethical, then you should be candid and honest to clients and tell them that this is a losing case. So that is one thing I'd like to articulate. I'd like to talk to the lawyers. I'd like to talk to the academe. I'd like to talk to the judges. I would like to explain to them that courts were created not for the benefit of lawyers, not for the benefit of judges, but for the benefit of the public. The courts are there because they're supposed to settle disputes, controversies. And there is no rhyme, reason, and logic for a case which is meritorious to go through the whole process of passing through the first level, go to the second level, go to the appellate court, and go ultimately to the Supreme Court. And because of the perception that the Supreme Court is the final arbiter, a litigant with a meritorious case has to wait until it reaches the Supreme Court before he gets relief. That might be a simplistic way of looking at things. In the same token, if a case is initially not meritorious, then it should be dismissed outright. That is why probably one reform that we should initiate is that we should impose some kind of sanctions to lawyers who file cases which are not meritorious, motions which are dilatory, and even appeals which are frivolous. Now, it might appear as fighting a windmill, but what I propose to do is to convince the Supreme Court to call a consultative summit, the same as the summit called by Chief Justice Puno I was a part of it, on extrajudicial killing and enforced disappearances, the summit on access to justice, and other summits. And this was a very unique and a bright approach, because this is similar to a JELAC, a consultation of the judiciary, the executive, and the legislative, because the Supreme Court invited resource speakers from Congress, resource speakers from the executive department, out of which they were able to craft the writ of amparo and the writ of habeas data. Now, I'd like some kind of a consultative summit to discuss this infrastructure of delay. Now, this will of course be resisted by lawyers and judges. And because of the orientation of lawyers and judges, lawyers are taught in school that they have to go to trial so that they can win the case for the clients, okay? Which is wrong, because if from the very inception the case is not really meritorious, there is no need to go to trial. That's why in pre-trial we teach lawyers and judges about stipulations of facts, modes of discoveries, and things like that. So I do not think, no survey has been made insofar as the litigants are concerned whether they're happy with the decision, even if they win the case after 5 or 10 years in the Supreme Court, for example. Nobody conducts a survey and asks the litigant, are you happy with the outcome of the case? And in all probability, they are not happy. That is why we have to teach lawyers that they are, we call them the priests in the temple of justice. If they're able to settle the dispute between the litigants, then they're successful. And if they're not able to settle the dispute, then they're not successful. We have to reorient because...
Excuse me, Justice. In as much as there are other matters that I would need to inquire from you,
all right.
Perhaps you can move on to the next topic.
Okay. You're right.
Incidentally, how is your health? Have you had any major procedure done on you lately?
Yes. I had a heart bypass in 2005. It was asymptomatic, meaning to say I did not feel any symptom. But since I had consultations, lab tests, and it was found out, then I had a heart bypass in 2005. I had an angioplasty in 2012. It was also asymptomatic because I see to it that I have a cardiologist. I consult him at least 4 times a year. I have my lab test every quarter. And then I have a pulmonologist who checks on me. I have an ENT. I have a prostate doctor with me because of my age. I have a knee doctor also. And they have already issued medical certificates attesting to my health.
In January of next year, you will turn 68.
Yes, Your Honor.
So that would leave you with 24 months before you reach the mandatory age of retirement of 70.
Yes, Your Honor.
With 24 months, and if you are to be nominated and appointed to the High Court, you would have to take on over 1,000 cases, which would translate to roughly a minimum of 40 decisions monthly. I was looking at your average monthly disposition per your personal data sheet, and it states 11. How do you expect to be able to finish the caseload that would be given to you within the time frame prior to your
Well, it remains
retirement?
to be seen, and I have no pretensions that I can finish that much compared to the other justices in the Supreme Court. But what I'm saying is that within the limited time frame, the limited period of time within my judicial career, I'll be able to concentrate not only on the disposition of cases, but also the judicial reforms I was trying to articulate. As far as I'm concerned, this is a way of I'm not fixated about going to the Supreme Court for myself. I was asked that question in 2009, and I said I wanted to be in the Supreme Court because it's the dream of all lawyers. Now, in the remaining period of my judicial career, it's more altruistic. I want to pay forward. I want to institute reforms. I want to articulate these reforms to lawyers, to judges, and even to the court, which I cannot do with authority and probably influence as a Court of Appeals justice.
Thank you, Justice TIjam. That was my last question, and
Thank you.
good luck.
Thank you, Your Honor.
Thank you. Thank you, Justice Gutierrez.
Thank you so much, Attorney Cayosa. May we now request Attorney Mejia.
Thank you, Madam Chair, and good afternoon,
Good
Justice
afternoon, Your Honor.
TIjam. What is your view on justices socializing?
Well, it invites undue influence, but the upside of it is if you socialize with people and you have your pictures taken, then you can use that as a reason to inhibit from the case. That's why when I attend alumni homecomings, I always have a picture taken with my co-alumni, and I always tell them, if this picture comes out, I have no other choice but to inhibit. But I think socializing when you're in the appellate courts should not be, it should be limited, it should be restricted. Probably socializing with fellow members of the judiciary would be okay.
In an ideal setting, Justice, how much access to the court should be given to the public?
Transparency, access. I think they should have more access in terms of active representation, so that their cases are heard. Insofar as access to documents, court records, I think they should be given access. They should be given proper representations. I know that there is a public attorney's office in the Philippines, which is similar to the public defender's office in the United States. But it may be a good idea, if worth looking into, if there are very few POW lawyers to attend to not only indigent but clients or in need of lawyers, there might be a need to adopt something similar to the United States, where even private lawyers are allowed to render services, but they're paid by the state or something like that.
Let me turn to one or two Twitter questions.
Okay.
You announced in an MCLE session that you were President Duterte's classmate. Considering your closeness to the President, how can you maintain your independence?
Well, that's a valid observation. Independence. I know this president. I know where he's coming from. He's full of pride. He's not that kind of a person who would ask favors. Let me just briefly tell you, Your Honors, that I was appointed by President Ramos in 1994 as RTC judge. I was appointed by President Gloria Macapagal-Arroyo in 2004, 2003 as Court of Appeals judge, and none of them had ever made any overtures to approach me about cases. I was appointed by President Ramos as RTC judge, and yet I decided the case of the writ of habeas corpus case of Filimon Popoy Lagman, an NPA leader who was arrested without warrant by the police at that time, and I ordered the release, and I granted the writ of habeas corpus. Gloria Macapagal-Arroyo, President Gloria Macapagal-Arroyo, I decided during her incumbency, I issued a writ of amparo against her and Gilberto Teodoro, Secretary of National Defense, and other generals in connection with the abduction of Phil-American activist Melissa Rojas. And then I also decided the case of the midnight appointees of President Arroyo, thereby revoking almost 600 midnight appointees. So what I'm saying, Your Honors, is that presidents or even their subalterns do not really make any attempt to influence judges as a general rule. And I have never experienced that. Now, with this president, I don't know if he remembers me. I don't even belong to any fraternity in Sambeda. And knowing him, he's full of pride, you know, his personality. He would be the last person to ask favors from people in the judiciary.
My final question. Good luck, Justice TIjam, and
Thank you, Your
thank you,
Honor.
Madam Chair.
Thank you so much, Attorney Mejia. May we now request Judge Ilaw.
Thank you, Madam Chair. Good afternoon, Justice TIjam.
Good afternoon, Your Honor.
Your present caseload is 91, and your average monthly disposition is 11.
Yes, Your Honor.
Do you think this disposal rate is sufficient enough, given
Well-
the caseload you have?
Yes, Your Honor. Taking into account that in the Court of Appeals, you do not only attend to your own decisions, but also the decisions of the other members of your division. I'm the chairman of the 4th Division, and occasionally you are included in special divisions in the Court of Appeals. Now, there might be improvement on my part to increase the output, the caseload output, considering that there are more lawyers given to justices in the Supreme Court rather than in the Court of Appeals.
All right, there is a Twitter question here that's addressed to all the candidates.
Yes, Your Honor.
How do you view the credibility of the current Supreme Court?
I think the Supreme Court has maintained its utmost credibility as the last bastion of justice. People always look at the Supreme Court as the final arbiter of all controversies. That is why even litigants who are in a hurry, instead of filing cases before the lower courts, they immediately file cases before the Supreme Court. So I think that's a recognition of the respect and the high esteem given by the public.
You have mentioned your advocacy or reforms to be undertaken if appointed to the Supreme Court. People are aware of any internal strifes between justices in the Supreme Court. What reform or advocacy would you intend to do if appointed to the Supreme Court?
I'm sorry, Your Honor, internal strife?
Yes, this is common knowledge.
Well, I think...
When tradition is
Yes,
broken in
of
the
course.
appointment.
Even in the Court of Appeals, there are dissensions. But what I'm saying is, if there is a commonality which does not involve the interpersonal relationship between the justices, I think the members of the court may be persuaded to pursue something higher than their own personal interests. Most of the incumbent justices are personally known to me. Most of them came from the Court of Appeals. Some of them came from the Regional Trial Court of Quezon City, where I came from. 2 of them are my classmates, by the way. So I think it's a matter of enticing them to pursue something higher than their own personal interests.
All right, having been in the practice of in the private sector as well as in the government, you have seen both sides of the spectrum and the disconnect between the two practices. As a justice of the Court of Appeals, have you addressed this disconnect in the effective pursuit of serving justice?
Pursuit of serving justice. The disconnect. Yes, Your Honor. The delay is a frustration to all litigants. And I was talking of reorienting the mindset of lawyers and judges. Lawyers look at cases in court as a source of income, and judges look at it as a source of power and influence. That is why some judges are wary about having their cases consolidated with the cases of other judges. So the disconnect is because the lawyers, the judges, are not in sync in looking at the purpose why they are in the court. Their principal client are the litigants, the public. And if I may just add, when President Duterte, when he took his oath, he said something about queuing. He doesn't want queuing. I think he was being polite and modest. As a lawyer, he knew that the longest queuing is in the judicial system. That courts are there to help the litigants settle their controversy at the soonest time possible. And I would like to achieve that by convincing the court to introduce certain reforms. Justice Abad was almost successful in pursuing that reform pattern after the European system of confrontational, wherein the judge takes an active role in the trial, and I was invited to be a member of that committee.
You attended and was the Master of Ceremonies of the 2011 Anti-Illegal Drugs Forum.
Yes, Your Honor.
What did you learn from that forum that you could apply today in support of the present administration's war against drugs, or illegal drugs?
Yes, it was actually...
If appointed as a justice of the
Yes,
Supreme
Your Honor.
Court.
It was actually sponsored by the Supreme Court, and there were participants from the Department of Justice, participants from the PNP, participants from the military, and I think at that time Secretary of the Interior and Local Government, Secretary Robredo, was even present. That was months before he died. Now, in support of the campaign of the President on illegal drugs, I'd like to mention that a few years ago, I conducted lectures on searches and seizures among police officers. And I think they're very receptive to getting some kind of orientation from the judiciary on relevant jurisprudence that would make it valid and legal for them to conduct valid searches and seizures. And I was even suggesting to them that they should carry with them some kind of a handbook so that at any time they can always refer to it and consult it on what is allowed and what is not allowed. So in that sense, the judiciary can support the campaign. Now, another way of supporting the campaign of the president is by deciding drug cases as swiftly as possible, even if we dismiss drug cases. But in the process, we tell the government about the pitfalls that should be avoided and the things to be followed to pursue a successful prosecution. Then in that way, we will be able to help the campaign of the president.
You likewise attended the two-day National Consultative Summit on Extrajudicial Killings and Enforced Disappearances in 2007. What have you learned from this summit that could be applied today in relation to the purported extrajudicial killings?
Well, the issuance by the Court of the Writ of Amparo, the writ of habeas data has been an instrument to protect the helpless, the weak. Up to now, we are even in the Court of Appeals, we are conducting hearings relating to the writ of amparo and writ of habeas data. Even the case I decided 2 or 3 years ago, the case of Melissa Rojas, which went up the Supreme Court, was remanded back to us for the purpose of looking at the actual perpetrators of the abduction of Melissa Rojas. It is still pending in my division, Your Honor.
All right, thank you very much, and good luck to your journey, Justice.
Thank you.
Thank you so much, Judge Ilaw. A while ago, in answer to the questions of Attorney Cayosa and even Judge Ilaw, you were discussing about delay.
Yes, Your Honor.
You know, this is my observation, Justice. No matter how many consultative summits, no matter how many circulars, memoranda, no matter how many classes are being offered by the PhilJA, if the judges are lazy, no way. There will always be delay. So it depends upon the personality of the especially trial judges. That's why they should be encouraged, they should be taught to change their attitudes. This is the basic reason why there is delay. The judges are unconcerned of their mission. The judges are tamad. That's my observation. You know, during our time in the RTC of Manila with Justice Pardo, Justice Callejo, et al., there were no complaints about slow disposition of cases. So this is really a very, very big problem because it concerns the attitude of judges. Well, I'll go to another. This is the first question. Do you think Rule 65 is an obstacle to speedy disposition of cases?
Well, petitions for certiorari, while a case is still pending before the lower court, may delay the prompt disposition of the case before the lower court, but it affords the litigants the opportunity to bring to the Court of Appeals the question of grave abuse of discretion, which can be corrected as soon as possible, Your Honors. So it's a way of balancing things.
You know, as what you said, sometimes lawyers are abusive. For simple orders issued by the lower courts, they would go up to the Court of Appeals or to the Supreme Court.
Yes, Your Honor.
Are you a member of the Committee on Rules? the
Yes, Your
Supreme
Honor. I am
Court?
a member
Maybe
of the Committee on Rules.
you can recommend that all these lawyers should be penalized, just like in the States. You know, if they raise pleadings, motions, which are really unmeritorious, they are being fined or even sent to jail by the courts concerned. So maybe, you know, you can take action on this matter.
Yes, Your Honor.
Anyway, you know, one of the rules of the JBC in determining the qualifications of candidates for nomination is to test their mastery of laws, rules, and regulations. Anyway, simple question, Justice, because you're going there to the Court of Appeals if you're lucky enough. There are 4 requisites when a petition questioning the constitutionality of a law, statute, or executive issuances are required before the court can take action their own. So what are these 4 requisites
Well, there
before
must
a
be-
constitutional issue may be looked into by the court?
There must be an actual controversy between the parties. The parties filing the case must have legal standing. The question of constitutionality must be raised
At the earliest.
at the earliest time possible, and that the issue of constitutionality is the main core of the controversy that has to be resolved by the court.
You mentioned about locus standi. When can a private citizen, for example, you and I, go up to the Supreme Court questioning the constitutionality of a certain law?
Well,
The question is, do we have locus standi?
there's such a thing as a taxpayer suit.
We are not taxpayers. You and I are ordinary citizens.
Well, if it involves a public right, probably that would affect the public, and even if we do not have, in some cases at the Supreme Court, I came across, even if there is lack of legal standing, if the matter is of transcendental importance, the court would take cognizance of it.
So you and I are raising a matter of transcendental importance.
Yes, if
correct.
it is.
What is the other ground?
A public right, Your Honor. If it's a
No,
public.
you and I have sustained a direct injury.
The direct injury
because
test.
of the unconstitutionality of the statute we are questioning.
Yes,
Okay. One of the prominent cases decided by the Court of Appeals last year is this case concerning Mayor Junjun Binay, where in your court issued TRO. And the case reached the Supreme Court. What was the decision of the Supreme Court penned by Justice Bernabe?
It said that the condonation doctrine has been abandoned, but the pronouncement is prospective.
Yes,
Prospective.
that is correct. But what is or are the grounds relied upon by the Supreme Court in ruling or declaring that the application should be prospective? Meaning to say, condonation doctrine is no longer acceptable. So what are the reasons?
Well, the condonation doctrine has been abandoned because violations of the Anti-Graft and Corrupt Practices Act should not be erased by the mere election of the respondent to public office, I think, because a public office is a public trust.
Officers and employees are required at all times,
Yes, Your Honor.
even if before election, because election is not a mode of condoning
Crimes.
not crime,
Yes,
administrative offenses.
Yes, Your Honor.
Okay. Next question is, Justice, Do you think President Aquino can be charged criminally on the basis of the declaration or ruling by the Supreme Court that DAP is unconstitutional?
Presidential immunity ceases.
No, now that he's
Now,
no
yes,
longer
yes.
president.
Presidential immunity ceases when the president is no longer the incumbent, so it can be filed. I do not know, Your Honors, exactly the basis, that basis, and this is something prospective which may reach the court. And whatever opinion I will share with you might be resented by the few remaining friends I have in the Supreme Court, and it might be construed also, as well as prejudgment.
Don't worry about it, Justice. You are safe here.
This is recorded, Your Honor. I don't know exactly the elements of the crime that will be embodied in the information that may be filed. I don't know. I don't have any complete appreciation of.
But have you read the decision in the DAP?
Not very well, Your Honor.
But you have an understanding of
Yes,
its
I
rule.
have an understanding about the statement about. I'm sorry, I could not remember the phrase already. Post-operative fact or something like that.
Operative fact doctrine.
Operative fact doctrine.
What is it? What is the meaning of it? Just
It completely escapes my mind, Your Honor. I'm sorry, Your Honor. I cannot give you a complete answer on that.
operative fact doctrine is the existence of laws or issuances declared unconstitutional, but all the acts done prior to such declaration remain valid.
Yes, Your Honor.
So, on the basis of that, do you think President Aquino can be charged?
I do
Is,
not know.
number
Your
one,
Honor.
is
I do
first,
not know,
was he the author of the DAP? Because under,
I think
pursuant to that decision,
as-
only authors can be charged
Well, it's a matter
criminally.
of evidence. The budget preparation emanates from the Department of Budget, which is under the office of the
That is
President.
disbursement acceleration program,
Yes, Your
meaning to say the office of the president, spend funds
Yes, Your Honor.
from other sources, and then of course you understand what is cross-border transfer. That is the DAP.
Yes, Your Honor.
So
it's
I give you the read that decision. So good luck.
thank you, Your Honor.